Well, we want to emphasize the leaked draft opinion is just that it's a draft, but it already has people asking about the implications beyond abortion rights if it turns out to be the court's final ruling.
The Verify team has been all in on this ruling, and Abby Larico joins us now with what they found. Morning, Abby.
Hey, good morning, ladies. So abortion rights are up for discussion in the Supreme Court this term because of one case, which is a challenge to restrictions in Mississippi. But if it goes through, if that is the final ruling, it is about the Constitution of the United States and what rights are clearly defined, which are implied, and which are not protected. The Roe v. Wade decision back in 1973 came down to right to privacy, which usually rests on two things: due process rights and the 14th Amendment of the Constitution, which protects the right to life, liberty, and property. But this draft says the right to an abortion was wrongly considered an implied constitutional right in Roe v. Wade. So let's verify. What other decisions rest on those implied rights? Our sources are Caroline Fredrickson, a Georgetown law professor, and Robert Peck, a constitutional law expert.
There's an interesting philosophical decision that's embodied in this opinion, and that is, to what extent are rights implied by the Constitution? This opinion asserts that abortion is not one of those implied rights.
There are other subsequent decisions dealing with equal marriage, gay marriage, and so forth that rest on the same foundation.
The idea of an implied right to privacy is the foundation of these other big decisions, like Obergefell versus Hodges, the case that legalized gay marriage, and Loving versus Virginia, the case that legalized interracial marriage, as well as Griswold versus Connecticut, which affords married couples the constitutional right to buy and use contraceptives, and Lawrence versus Texas, which made same-sex sexual activity legal in 2003. As for whether those cases are at risk, it's hard to say. Justice Samuel Alito, author of the draft opinion, argues the abortion issue is, quote, critically different from any other right that this court has held to fall within the 14th Amendment's protection of liberty. But for nearly 50 years, abortion has been considered a procedure that fell under the implied rights umbrella.
It basically is an invitation to those who oppose those decisions to come back to the Supreme Court, frame your arguments the same way that this case really opinion.
So while some legal analysts say Alito has addressed those other rights in this draft opinion, others are concerned this decision would be like a roadmap for overturning other rights as well. The Supreme Court decides what rights are guaranteed in the Constitution, explicit or implied. So Tony, still a lot to watch for this one.
Absolutely. A lot to unpack. All right, Abby, thank you very much. And again, we want to stress Roe versus Wade is still the law of the land, at least for now.